East Africa Law Society here in Arusha, Tanzania, and hope that you're all doing well. Now, this afternoon, friends, we are very delighted to host a very esteemed discussion on how mergers and acquisitions in East Africa are being rewritten by geopolitics, competition law, and a new generation of investors. And taking us through this session this afternoon is one of the very eminent advocates that are from across East Africa, and we are delighted to have her here at the East Africa Law Society. That is none other than Miss Elizabeth Musikali. Now, for those of you who have interacted with Miss Elizabeth Musikali, you do know that she is a lecturer of law and an advocate of the High Court of Kenya, but also an esteemed member of the East Africa Law Society. Good afternoon, Elizabeth, and it's a pleasure to once again host you this afternoon. I will hand it over to you to introduce the session, but also introduce to us this lovely panel this afternoon. Over to you, Elizabeth.
Thank you very much, Gabriel. Thank you for that very good introduction. So good afternoon, everyone. I'd like to welcome you once again to this afternoon's discussion on how mergers and acquisitions in East Africa is being rewritten by geopolitics, competition law, and a new generation of investors. So I'll introduce the session today, and then we will have our panelists. I will do their introductions, and then we will proceed from there. So as you know, the East African mergers and acquisitions landscape is undergoing one of the most significant transformation in history. Kindly let me know if there's an interruption in the background as we proceed. Can be able to handle that. Thank you. Right. So for decades, transactional lawyers operated within a relatively predictable environment, and investment capital flowed largely from traditional Western markets. Regulatory scrutiny was often limited to corporate approvals and sector-specific licensing requirements. Deal success depended primarily upon valuation, financing, and effective execution. That world no longer exists. Today, the modern East African transaction sits in the intersection of law, geopolitics, economics, national security, competition, regulation, environmental governance, and international diplomacy. Every significant deal now carries several implications that extend well beyond the boardroom. Competition authorities are exercising unprecedented influence over transactions. Governments are increasingly scrutinizing foreign investment in strategic areas. At the same time, environmental, social, and governance considerations have become central to transaction planning. Investors, regulators, lenders, and consumers are increasingly expect businesses to demonstrate responsible governance, sustainability commitment, and measurable social impact. Transactions that fail to account for ESG risks may face regulatory obstacles, financing, and challenges. Lawyers advising on mergers and acquisitions, but they must therefore navigate a far more complex landscape than ever before. So to take us through our session today, we have 4 speakers who I will introduce. We have Ms. Felista Kimanuka, who is a seasoned corporate lawyer with over 15 years of experience advising leading organizations across Africa. She specializes in corporate governance, mergers and acquisitions, banking and finance law, and regulatory compliance, with a strong record of structuring complex cross-border transactions and guiding boards on best governance practices. She currently serves as a company secretary and general counsel at the Bank of Kigali PLC, where she leads legal and corporate governance functions, ensuring alignment between commercial objectives and legal safeguards. Prior to this, she was the country head of legal and company secretary at Bank Populaire du Rwanda, and earlier served as the chief legal advisor and company secretary at Rwanda Limited, where she negotiated high-value aviation contracts and provided governance advisory. She also holds an LLM from the University of Manchester and an LLB from the University of Witwatersrand, a diploma in sustainable business and responsible leadership from the Swedish Institute of Management, and a postgraduate diploma in legal practice from ILPD, Rwanda. Welcome, Felicita.
Thank you. Thank you, Elizabeth. It's a pleasure to be with you.
Welcome. We also have with us Mr. Ali Kamanga, who is a manager for the mergers and acquisitions in the competition division, mergers unit at the COMESA Competition and Consumer Commission. He has worked with the commission since 2016, focusing mainly on assessment of regional mergers. And before this, he worked as the Assistant Director of Trade at the Ministry of Trade in Malawi, where his role included overseeing the setting up of Competition and Fair Trading Commission of Malawi and implementing regional and continental integration matters under COMESA, SADC, and Tripartite Free Trade Area and the African Continental Free Trade Area. He holds a Master's of Arts in Economics degree and a Bachelor of Arts in Social Sciences from the University of Malawi and a professional certificate in international trade from the University of Adelaide. Karibu, Mr. Kamanga.
Thank you very much. It's a pleasure. Thank you.
Our third speaker for today is Bertha Nyahoro, who is a corporate commercial lawyer and investment advisor with over 7 years' experience in cross-sectoral practice, focusing on high investment undertakings, infrastructure projects, tourism, energy and mining sectors. She advises clients on complex legal and investment issues and represents operators in high-level agreements and engagements. And she has advised multinational corporations on competition-related issues for international construction service agreements and has successfully advised, negotiated, and structured complex agreements in various sectors, including tourism, hospitality, mining, and construction. And additionally, she has been instrumental in liquidating the first insurance company undertaking involuntary winding up in Tanzania and successfully closed more than 10 M&A transactions. Karibu, Bertha.
Thank you very much, Felicita.
And last but not least, we have with us Mr. Ian Mutibwa, who is a partner at SM & Co. Company Advocates, and he is in the tax department. He's both Ugandan and UK trained and has more than 10 years experience in practice. And in 2016, he was seconded to the global law firm of Latham and Watkins LLP in the UK in the International Tax and Project Finance departments, with a special emphasis to the African market. This was under the International Lawyers for Africa program, and he has twice been nominated for the award of Partner of the Year at the African Legal Awards in 2020 and 2021. And he was also recognized amongst the 75 highly regarded business lawyers in Uganda and is a member of the East Africa Law Society and the Uganda Law Society. Karibu, Mr. Mutibwa. Now, to start us off for our discussion today, we will have a presentation by Mr. Mutibwa, who will take us through who is buying East Africa and why. Karibu.
Thank you, Elizabeth, for the kind introduction. Good afternoon, fellow panelists and members who have joined us. I see 65 people online. My name is Ian Mutibwa. I'm a partner with SM & Co. Advocates. I head the tax department. I like to joke that I also head the entertainment department. I like entertainment, so I also do entertainment law. But today I'm here in a different bracket talking about new investors of East Africa, who is buying and why. It's going to be a short presentation, and I will be happy to take questions thereafter. So please, let's go through this. Yes, I'll start off with the deals that have happened in this year in East Africa. And I'll start off with a statement that East Africa is not being abandoned, it's just changing hands. you realize that many times we've had different investors coming from the West, as Elizabeth rightfully put it, and we're seeing a shift into investors coming from the East, and to add also coming from the USA and the greater part of Canada. We've seen funds changing to private equity and venture capitalist funds, sovereign wealth funds, family offices. Those are coming in into East Africa and are coming into the world market to finance. So generally in East Africa this year, that is between January to April this year, we've seen a total of 47 deals closed. The total value of $357 million across 5 markets and 1 major exit. And that is the Aga Khan exiting Nation Media Group, and we shall have a discussion in that. We've seen deals rising between January and February across to March, and these have been shared equally in the East African countries. What is unique about these particular deals is that instruments are more debt-shaped, and they are moving around more debt instruments coming into East Africa. And we shall see those particular discussions as they move along. So on the sovereign wealth funds, we've not had any traction in East Africa for this financial year. I'm looking at 2026 specifically. And that's because the sovereign wealth funds are still building momentum to come into the different markets. We see that some of the wealth funds have invested heavily in private equity. We've seen a couple of deals being closed by TLG Africa in Malawi and Uganda. But part of the people financing them are the Swedish Wealth Fund. So we don't see the direct investment of wealth funds in East African market, but they really come sometimes in the guise of private equity, where they invest their money, and then the private equity comes to on lend onto the different companies in East Africa. So what we need to do as East Africa is, one, to build capacity so that we can be able to absorb some of these monies that coming from different sovereign wealth funds or different jurisdictions. The Gulf and the Asian funds are really interested in East Africa, but they usually fund the ports, logistics, agriculture, and we shall see what share those particular sectors have had in the different markets. So as of to date, and this information that's available, we have not had a significant sovereign wealth fund direct investment in East African market, but we know that they've been investing through some of the private equity deals. So who is actually transacting? Where is the most of the money, the bulk of the money going? We see that one, private equity is taking up a bigger chunk of the investments. I see M&A, strategic M&A happening in different jurisdictions. I see the financial institutions that had some M&As looming, and some other jurisdictions. I shall see the different sectors that these M&As have happened. Venture capital has also come in. This is mainly on startup investments, technology mostly. There are a lot of venture capitalism that's happening there, and we see a shift in financing of those startups, particularly for tech-driven and data-driven companies. We also see a lot of DFIs. DFIs also starting to put a little bit more concentration in East Africa. We've had 4 deals happening between the period of as at May of 2026. The exits that I've told you, we'll talk about the exit, sovereign wealth 0, and then a commercial debt. But we can see that a lot of private equity is coming into the market. This is particularly unique because most of maybe let's say give or take 10 years ago, most people did not quickly uptake private equity because of what it would bring to the different businesses. But it shows that the market has really understood what private equity is about, and they've really welcomed the issue of private equity. We shall see the pitfalls of private equity that are happening in the investment space at the moment as we move along this particular training. New strategic investors in East Africa, we've seen a lot of movement in Kenya, especially as regards Nigerian banks. We've seen Zenith Bank take over Paramount Bank in Kenya. It's a $7.7 million transaction that was in April of this year. Also seen a 78% acquisition of Somac Microfinance Bank at the 31st of March by a Nigerian Money Point. We've seen Taifa Gas coming into the energy space in Tanzania, and also seen the health space being taken over by Indian investments in Uganda, where UMC Hospital was given an investment. So what does this mean? That your client is no longer the London fund that you're looking at. You're looking at next door neighbors, Nigeria, across Tanzania, and across the Far East, coming into the different East African countries to do the lending and taking over the different businesses that we have in East Africa. The biggest deals that have happened in East Africa, we've seen this DFI. We'll look at development finance. So development finance brings in big, it's big, and cuts across sometimes jurisdictions. So we look at the Impact Fund of Denmark, coming in the biggest check of the year so far, $25.6 million. And this is in a New Forest company. And this is a cutting across timber processing in Uganda and Tanzania. This happened in May of this year. So that's one of the biggest deals that has happened in East Africa at the moment. We see British International Investments with $15 million in Kenya. Agdev company coming in with $50 million for tilapia farms around Lake Victoria and Lake Kivu. Oiko Credit also coming in with structured debt for Osawa Energy. We'll see a lot of investments in energy and renewable energy to be precise. Swede Fund coming in with $600,000 for a hospital, affordable maternity hospitals in Nairobi as well. So looking at 4 deals happening, DFIs contributing a total of $46.2 million, and the biggest one coming from Impact Fund of Denmark, investing in Uganda and Tanzania as of 20th of May. Now, this is an interesting part about private equity. So private equity holds the most money, as we've seen. It has the most investments coming into East Africa, but it is not coming as private equity. It's more or less coming as private equity debt or private debt. So you'll find that most of the investments that have happened, they are more on a private credit or less on private equity. So you'll find that majority of the equity deals that have happened is more on a lending perspective. And that has an implication on the businesses we have in East Africa. Most of the investors are skeptical to come in and be co-investors and exit at a certain point. They rather come and give debt, and that debt has a maturity period where they can exit. There's a lot of money happening, there's a lot of money flowing into East Africa through private equity, but we see an increasingly a debt structure is coming in more than the equity side of it. That's for private equity deals in East Africa. Again, for the period I'm looking at is period of 2026, year to date. Venture capital has also closed 4 deals this year. 1 deal in the last 3 months. There's been no deal in May. It's a total of $18.9 million. And the most talked about deal is Dodai. That's in Ethiopia. It's a $13 million Series A investment in electric motorbikes. And this is an inclusion of different investors, Tokyo platform, Inclusion Japan, Persistence SCV. Those are people who came along to make this particular investment. This investment is in Ethiopia. And I particularly put Ethiopia, not Nairobi. Most of the deals Kenya has taken out to be a hub in most of these particular investment transactions. And you see that Ethiopia is also trying to come in strong on issues of harnessing some of these financing and capital. So we see this Series A financing in Ethiopia going towards green energy, electronic motorbikes, and battery swapping. So those are some of the deals that people are looking out for in this particular market in East Africa. So as we looking at the different transactions, different deals happening in East Africa, we need to look at the seller side or the sales side. That's where the story is. So I've talked about the exit of Aga Khan Foundation or Aga Khan Fund for Economic Development, exiting Nation Media after 66 years. So they sold 54.8% to to Tarifa Limited, Tanzanian family investment that has taken over control of Nation Media Group as we speak. That's one of the biggest exits that we've had in this financial year, and it's one of the exits that are being talked about in this. But as I told you, that your investors are now more closer to you than they were before. So we're seeing people across the different jurisdictions, across different regulators, coming in to acquire big conglomerates or big companies that have been in existence for a period of time. What that means as well is that people who are now have held on to this legacy business are trying to exit and are selling to maybe quote unquote new blood to come in and revive these particular businesses. We've seen also an exit of Oka Exploration for Taifa Gas in Tanzania, again 49% in Pan-African Energy. We've seen a sale of East African Cables or Trans-Century selling its stake in East African Cables, and this also happened as an exit story. So we've seen an arrival of Tarifa Limited coming in to take on a good stake in Nation Media. We've also seen Taifa Gas as well as Cable Experts coming into the market to acquire the biggest stakes. So we need to look at the fact that we've seen that family offices. So family offices, these are usually big conglomerates of family-owned businesses or family wealth, which come in to acquire and start doing their own private investments. So we're seeing this as a new trend as well coming in. We have family offices from Saudi Arabia. We have family offices from different different aspects different investment families from Saudi Arabia, from France, United States. We have Tanzanian family members. So we've seen a lot of family offices or family businesses coming in to do these big investments in East Africa as well. So where is the money going? Where is the biggest money being invested in? So most of the monies that have come into East Africa are going to agribusiness, not farms, but agribusiness. Financial services is also attracting a lot of investment there. Automotive, energy, healthcare, logistics, professional services, hospitality, mining, and manufacturing. So I want to talk about agriculture or agribusiness. I'll speak for Uganda, which we usually say that the backbone of Uganda's economy is agriculture. And we've seen this happening quite a number of times. So agribusiness is going to mainly coffee processing, aquaculture, timber milling, farm inputs, agri-lending, and they're looking at a lot of infrastructure development towards agribusiness, so that this particular end of investment can take root. So this is where most of the investments. So we're seeing that 27 out of 47 deals have happened between January to now. Is 27 of them are in agriculture or agribusiness and financial services. That's where the lenders are looking at concentrating. So as we move along, one of the things we need to ask ourselves is, what are lenders more interested in, especially like geopolitics that happen in the different jurisdictions? We know Africa is largely a young population, and we have a lot of market for different products that are being consumed. So many of the investment decisions are going to be made based on that market presence, having a young population and having a market. There's going to be a lot of rapid urbanizations, making sure cities like Nairobi, Kampala, Dar es Salaam, Kigali are growing, and the demand is also growing. So many investors are coming in because of that particular demand. We have digital adoption. We see a lot of e-commerce coming in, mobile money, internet connectivity, things to do with fintech and logistics are coming in to make sure that the investors come into East Africa. However, one of the two bigger issues that they usually have questions on is political overlay. And I want to concentrate on two countries which have elections. Uganda had elections in January of this year, and Kenya is having elections in August of 2027. So I've interchanged these words to bring some clarity. So Uganda has certainty without comfort. Kenya has comfort without certainty. What does that mean? In Uganda, we're more or less sure that President Museveni is going to be the president. He's winning 71.6% against 24%. All that is certain. There's some certainty on who's going to be the next president. But the comfort around that, if you look at the election period, there's a lot of post-election unrest. There's a lot of business interruption and connectivity issues, which then bring in material adverse changes, clauses, as well as force majeure clauses in different investment contracts, sanction of human rights, screening, and things like that. So there's a lot of discomfort in Uganda. There's certainty, but there's discomfort. We've just recently passed the Sovereignty Act, which has been a very big talking point in Uganda on how it plays around with foreign direct investment and moving monies in and out of Uganda. So there's a lot of discomfort in how these regulations change. Uganda is also a fast-changing environment as regards to legislation, especially when it comes to aspects of tax. We usually have tax changes at the beginning of July of every year. So many investors are keen to listen to what tax changes are coming in and how those are going to impact their businesses. So part of the decision that being made in investment come from the aspects of investing and having a certainty and comfort in that investment. Now, when you flip over to Kenya, there's comfort. There's near-term legal risk. It's more of a physical risk and not a security risk. So in Kenya, it's more who is going to be the next president. We have certainty to know who's going to be the next president, right? But they're not more concerned about security or the comfort around it. So they have the comfort without the certainty. And those are two things that really sometimes drive investors, especially in markets that are in developing countries like East Africa is. So some of those considerations that they make are on the politics, on the market and the demand and the supply, which we really have going our way, on government policies as well. What's government priorities of investment? So if you see agribusiness and if you see energy, you see financial services, that's where the government is usually looking at investing. Regulatory changes, investment laws, tax laws, as we talked about, licensing requirements, foreign exchange, and how your currency plays in the world currency that people trade in also comes into consideration as the new investors are coming into the market. So what does this mean for legal practice? One, we need to look at transactional structuring. So we see more and more debt and hybrid replacing equity. As I told you, most of the private equity is coming in as debt or as hybrid. We need to look at how that impacts our structuring of particular transactions and how we can convert the debt or equity, and how those two also play with the tax laws, especially in regards to expenses as allowed for interest and worldwide debt cap. So we need to have that structuring done right. Two, governance standards. We need to realize that most of the investors now are looking at impact investment. They're looking at how does this investment impact the market? What about the ESG standards? What about the integrity, the dignity? In the coffee space, they're looking at deforestation coming into the different areas where coffee is actually being planted. So we're looking at more impact, more governance standards. They're looking for more requirements on governance and more requirements on how that financing is going to be, is going to affect or is going to impact society. Risk allocation also comes in. Many people are looking at how to close in the different risks that happen, that keep happening in the region. We know Uganda has been earmarked for Ebola, so that's a risk that most of the investors will face. How do we work around contractual documents to make sure that these risks and material adverse changes are not impacting in our different investments? Issues of drag along and tag along, and how the money that's going to be used to purchase is going to be distributed to the shareholders also is being heavily negotiated because they're looking at long-term exits happening. For example, the Khan Foundation exiting. How does that exit happen? How does it happen in that particular regime? Because sometimes the regime has changed, and we need to make sure that our exit complies with the regime. Case in point, someone's going to talk about issue to do with competition. How does an exit in an investment agreement tie along with the competition laws that have been developed in the different jurisdictions. And then the general legal advisory, legal and tax advisory. Are you advising an African investor, a DFI, a family vehicle? What are you using? Is it a facility agreement? Is it a credit note? Is it a promissory note? What are you actually looking at? And what are the paths for different regulators? Remember, sometimes these investments are across jurisdictions in Africa or jurisdictions out of Africa. How the different regulators interplay to make sure this drawdown or FDI is done is also very important. And then if you have a seller who has been holding particular assets for a long period of time, how does that exit look like? How do you negotiate that exit? How do you look out for people who are going to do long-term investments vis-a-vis people doing short-term investments? The different legal and tax advisory around that would come into play. So all in all, for my brief presentation, what I want the listeners to understand is that capital has not lost confidence in Africa or in East Africa. We have $357 million committed in 5 months, and more of that is going to come as we move along the rest of the year. But the issue is, how do we cover the undocumented risks? Because that is a legal problem, it's not an economic one. There's so many risks that are undocumented that we need to make sure that we cover as lawyers to make sure this FDI happens. So that landscape is changing. We'll see a lot of investments in agriculture, in technology, in the new industry. You see a lot of people playing from the east, moving from the west, playing to the east, and investors coming in. So we're looking at how that regulation, how the tax, how the regulatory environment, licensing environment has come in to interplay with those different investors coming into East Africa. Thank you for listening to me. I know I've been fast. I was given a period of 12 minutes, and I'm happy to take questions at this point.
All right. Thank you very much for that very in-depth breakdown on who's buying East Africa and why. The question and answer period will be at the tail end. So I'd like to encourage the attendees to continue asking questions in the Q&A or in the chat box. We will be able to handle them at the tail end of the session. So this will now take us on to the next part of our session today, where we will be discussing the growing influence of competition regulators. And we'll have Mr. Ali Kamanga take us through competition authorities and whether they are deal makers or deal breakers. Karibu, Mr. Kamanga.
Thank you very much, Elizabeth. I believe I'm audible.
Yes, you are.
Yes, thank you so much. My presentation will indeed focus on the regulatory aspects in respect of mergers and acquisitions, and I promise not to take a lot of time. But I think the subject that we're discussing is very important. So at times, if you just go a little bit over 15 minutes, I'm sure, Elizabeth, you will forgive me. So I'll just discuss the aspect of how competition authorities come into the picture in respect of mergers and acquisitions. I like the presentation that Ian has just made. I think there's a lot of points that I may also just speak to and confirm. So I'll not waste much time on the outline, but by way of introduction, I think as a regulator, it is very important that when we are in such forums, we always emphasize and remind ourselves whom you are talking to. So the COMESA Competition and Consumer Commission is a regional, competition regulator established under Regulation 8 of the COMESA Competition and Consumer Protection Regulations. I would very much like to point out and stress the fact that the regulations currently in force were approved in December of 2025. I'm sure there are a number of participants who know the COMESA Competition Commission, but it has since changed its name, and quite a number of regulatory aspects in respect of mergers and acquisitions has come into into the market, which I think is very important that we should, share this information. I know that being that we have lawyers, or rather counsel before us, certainly you have read the regulations, but you would want to appreciate that as a competition regulator, the scope or the aim of the regulations is indeed to promote, competition in the common market. I'll refer to the common market, but I do appreciate that we also have the East Africa, Competition Authority, which also has a regulatory framework for competition, aspects of which may be similar. So as competition authorities, we've got two major interests when it comes to mergers and acquisitions or deal making or breaking. We want to ensure that competition is restored or maintained in these markets. As well, we're very much interested to safeguard the interests of the consumer in the market. I have deliberately put up, a number of points as to the functions of the commission, but I'll just quickly, point out the fact that among the other functions that the commission is, charged with, there is, the mandate to monitor, investigate, and assess mergers. These are transactions that are likely to have effects in the common market or in the relevant markets that we would be dealing with. The same also applies to competition authorities at national level. The mandate does extend to similar to what the commission is set up to do. I've also brought up a number of points in relation to cooperation with competition authorities in member states as one of the key functions of the commission. This is very important, as you would appreciate that in discharging our mandate, we cannot rule out the fact that in Kenya or in Uganda, we do have other regulatory authorities who may also be charged with similar mandate as the commission, although there will be a difference in the jurisdiction or reach, that these authorities may have. So cooperation or coordination in our work is very important. In the regulations, if you take interest to read them, you would also appreciate that the cooperation with the various authorities focuses on a number of aspects. We do have cooperation mechanisms in terms of how we implement our decisions, as well how we monitor and regulate the markets, and the cooperation would also extend to other sector regulators. These are very important institutions that the commission cannot discharge its mandate without conversing with. Moving on, I think it is very important early on in this presentation to state that, as a competition authority, again, we've got our specific mandate, which would really influence or impact on how, these various transactions that, Honorable Ian has spoken about would shape up. So as a regulator for the authority, for the commission, ours is to ensure that the competitive process in markets, competition is protected, but as well that, that consumer that is sitting in Malawi, in Tanzania, and any other parts of this Eastern and Southern Africa region is, their interests are safeguarded. I've brought up the aspect of market inquiry, and I'll also be quick here to say that in the new regulations, in the current regulations, there's specific, mandate that the commission has been given to conduct market inquiries, which mandate can also or does also, extend to, requiring or requesting information in these various sectors that, these transactions would be affecting, which requests request that the expectation is that businesses would, respect, would respond, failing which there may also be some, sanctions that may apply. Not to scare the businesses or the lawyers, but it is very good that, we are transparent with how we conduct our work. Advocacy and awareness is also one of the roles that the Commission does play in the space of mergers and acquisitions and other aspects of competition regulation. One such advocacy would be this engagement. The more we interact and make the business aware of what the Commission is, the more sure we are that these regulations will be adhered to, and it also smoothens our enforcement of the law. At the end of the day, as a competition authority, we want to ensure that we have markets which are functioning, markets which are free of barriers to entry, and markets where competition is thriving. I also would like to point out, the aspect of ensuring that we are promoting investment in the region. Because you would appreciate that if an authority is not aware or cautious of the investment implications of a delay in issuing a decision on a major transaction, this is an authority that may be, a thorn to businesses, and we would not want to have such an authority. So we are very cautious to ensure that those investments that Mr. Mutibwa spoke about facilitated as and by the competition authority. Moving on, I'll quickly just run through the COMESA merger control regime, noting very well that there are other competition regulatory frameworks out there. But for the purposes of this meeting, I will limit my discussion on the COMESA regime. So indeed, I've already, I think, touched on these aspects, why we do have the COMESA, merger control regime in place. I think what is very obvious in the business world of today is that businesses are cross-border. Being cross-border, the regulatory framework that would handle such businesses, if at all there are any potential competition concerns, is a regional framework, is a framework that should extend beyond the competition authorities of member states of COMESA, such as Malawi, Zambia, or Zimbabwe. So as a regional major control framework, ours is to ensure that these cross-border mergers, transactions, or deals do not have a negative effect within the common market. We are also having a regional major control regime whose rationale is also to ensure that where any competition concerns are identified, these concerns are remedied and or prohibited to the extent that that prohibition is justified. It is also very obvious and very common, I should say, to note that most of the transactions that are happening in the region are transactions which are neutral. They are also likely to have positive effects on competition, and definitely these are transactions that would benefit consumers. As an authority, we are also very much aware, and when we are enforcing the law, we want to ensure that such transactions are not unreasonably delayed, because at the end of the day, these are transactions that we need for the region to grow our markets and to also ensure that those priority sectors, those agricultural transactions that Mr. Mutibwa referred to, are facilitated. Moving on, I'll quickly just point to some of the benefits that as attorneys, as businesses, you should know from having a regional merger control regime. So first and foremost, the COMESA merger control regime is, one that provides a one-stop shop for merger review or merger approvals. What do we mean here? As a regional, authority, and where, an authorization has to be given on a merger, such application and authorization will be made at one point. So this will be an application being submitted to the COMESA Competition and Consumer Commission. The commission assesses and the decision is issued. What would be the alternative in the absence of such cross-border merger control regime? It would imply that as businesses, they have to ensure regulatory compliance at each and every country or member state of COMESA, be it even the East Africa community, submit a filing, make, pay major notification fees in those jurisdictions and wait for a decision. What are some of the risks? Such decisions may not be decisions that are consistent. There may be, a lot of costs that are, associated with ensuring that you have filed and you have met, regulatory compliance in all these jurisdictions. And this may also be something that may, make the East Africa region or the COMESA region a region whose markets are not true investments. It is very encouraging to look at the numbers that the previous presenter presented. I think one can clearly see that there is business happening in the region. So we want to ensure that we are facilitating that business. If it is inflow of funds from outside the region, we want those funds to come, and there should be no such barriers. And one such mechanism from a regulatory point of view is to have a framework such as one we have at the COMESA region, which provides for such a framework where you would not need to knock the door of each and every authority in the region. Moving on, it is very important, I think, to also speak more of what or how the COMESA regional framework is provides for. So I've already spoken about the one-stop shop. So indeed, this is the principle that guides the enforcement of the COMESA merger control regime. So ours is to ensure that we're preserving the integrity of this one-stop shop. Very important as well is for us to point out that as a regional competition authority, we do have exclusive jurisdiction on notifiable mergers. So any merger that meets the relevant thresholds at COMESA, such a merger has to be notified with the Commission, and our law is very clear under Regulation 49. In that case, member states of COMESA are not to call for notification of such notifiable mergers, because calling for those notifications will take us back to multiple filings, which may lead to multiple payment of major filing fees, which may also be a cost on the business, which we don't want to, our businesses to have such costs where we can avoid it. Notifiable mergers are those mergers that obviously would have satisfied certain merger notification thresholds, which are provided for under the regulations. I've here just pointed out to Regulation 41, 5, 6, and 7, and Rule 3 of our COMESA Competition and Consumer Protection rules. These are very clear as to the criteria that a business can sit down and self-assess and say that, okay, because I've met these categories, I should then approach the authority at COMESA to seek an authorization of this major transaction. And just to also note that the Commission and most competition authorities do have thresholds, so that there's a transparent and predictable way, of regulating these major transactions. The thresholds would be those that would ensure that the Commission is not requiring each and every transaction, small transactions, to be notified to the Commission, because doing so may also be unnecessary. But as well, the assumption here is that those transactions that meet certain thresholds are transactions that may have an effect in a cross-border manner in the common market, hence requiring the notification. I would also point out here that as a competition authority, and as you would have seen from one or two of my first slides, authorities are there to ensure that competition is thriving, consumers are safeguarded. So the Commission would also invoke its jurisdiction on measures, even where the thresholds are not met. But where it is very clear that that particular transaction, if implemented, it may still raise competition concerns, even though the thresholds are not met. And here I'll point out to a very new dynamism that is coming into our markets, and this is to do with digital markets. So in digital markets, you've got certain types of transactions which may not necessarily be captured under the thresholds. But when you look at the implications from a competition and consumer perspective of those transactions, they are transactions that are worth looking at, because once you get, I'll just mention, the likes of, platforms which are very present in our digital space, acquiring small startups in our region. It could be the case that, the platform itself is not very much visible in the region, but futuristic development of that market may have implications to the extent that these small startups that we have in the region may not be able to compete, and they will be locked out of the market. Such transactions would ordinarily want to look at them because they have got competition and consumer implications. Moving on, I'll quickly just summarize and point out to some of the aspects of the thresholds that are provided for under the COMESA competition and consumer protection regulations. One is such that is provided for under Regulation 41.5, where the Commission would be interested in certain transactions where it is very clear that one of the parties is operating, is deriving turnover in 2 or more member states. We would also want to ensure that if the first point is indeed proven, in such a transaction, a target entity should be at least in 1 or more member states of COMESA. And we're also interested to know the value of the turnover or asset values that these businesses have in COMESA. And if it is the case that at least 60 million is combined turnover of the parties is derived in the common market, we would want to look at that transaction. And lastly, is also to look at whether these parties to the transactions individually they derive at least 10 million in the region, in COMESA region. These, if met cumulatively, would interest the Commission that that particular transaction is a transaction that we want to look at. Specifically, moving on to point number 2, under the regulations approved in 2025 December, there's also a provision for capturing greenfield joint ventures. So in the case of greenfield joint ventures, where it is also clear that the JV is intended to operate in 2 or more member states, where at least one parent undertaking is present in 2 or more member states, and again, the 60 million a combined turnover or asset value is met, such a JV would require notification to the Commission. Let me just point out here that, in joint ventures, especially greenfield joint ventures, there would be an argument that, can be put forth by businesses to say that, okay, we are in a JV, we are already existing players in this market. Our coming together is not going to have any impact on the market. The Commission would want to look at that, joining of, these two businesses to set up a JV, because that particular setting up may also have, certain business, implications or market implications from competition and consumer perspective, and would want to look at that and assess. Lastly, I did refer to, digital markets. A new, introduction in the regulations of 2025 is also a threshold for digital mergers. So transactions that are, taking place in the digital, market have a specific threshold that we want to capture them. And unlike the other 1 and 2, in a digital market, in a digital merger, we're interested to know the value of the transaction. So if a transaction meets the, the prescribed transaction value of $250 million, that is a transaction that we want to look at, to the extent that, one of the parties has got, operations in 2 or more member states of COMESA. Moving on this one, I'll not take so much time. I'll just point out that all major applications that would be made to the Commission have to be submitted in a prescribed form and manner. This is provided for under Regulation 42.3 of the regulations, and there's a specific form that has to be completed by the parties who are making these major filings, and major notification fees apply, and a specific fee also applies, or formula for calculating fee applies for digital mergers. But in all cases, there's a cap of $300,000 on these major filing fees that would be paid to the Commission. I think having reached this point, one would start asking, why is all this relevant to ensuring that deals are not frustrated or they are facilitated? I think to answer that question, if at all it is there, it is just to note that the current major control regime under COMESA, as is the case in most competition authorities in the region, is a suspensory merger regime, meaning that parties to a transaction that is notifiable are not allowed to implement that transaction before obtaining an approval from the Commission. If that implementation is done without the approval, it is a contravention of the regulations, and sanctions may apply, including penalties up to 10% of the party's turnover derived in the common market. I thought that point is very important to bring it forth, so that as we're advising on these deals, we're also aware that one of the conditions, one of the requirements from a regulatory perspective is to obtain an approval from the Commission. So a deal may indeed be stored if that approval is not forthcoming. Of course, as they always say that there's always an exception to the rule. The law has also provided for a derogation, from implementing such transaction without obtaining approval. And our regulation 42.2 and 42.7 has provided for the scenarios under which a derogation may be sought.
Right. Just
Yes,
sorry to interrupt you.
I'm running out of
in
time.
30 seconds, yes.
Yes, so quickly, just to note that I think the last point I want to share with the participants is that in the spirit of facilitating merger review or conclusion of deals, the Commission has also put in place certain procedures such as the expedited merger review procedure, which seeks to facilitate transactions where the parties may not necessarily want to wait for an approval within the statutory period of 120 days. We also do have options for legal advisory, or rather advisory opinions that may be sought by the parties on aspects of the regulations, and as well comfort letter requests. Allow me, Elizabeth, to close my presentation with one very important slide, which is the one I'm on now, which is to say that how then does the Commission discharge its work in the environment where these mergers are cross-border. So the law has provided for a cooperation mechanism where for each and every major transaction that is notified to the Commission, we are obliged to engage all the member states that are likely to be affected by these transactions. So the member state where these parties have operations. So we consult them, we consult competitors of the parties, customers of the parties, and any other stakeholders, including regulators, so that we get their views on these transactions before an approval is given. We also have a referral mechanism under the law where a matter can be referred from the Commission to a member state, having met certain criteria for that part of the transaction to be reviewed by that particular member state. There's one matter which I think we have handled previously, the KNSL, KPA, SAS merger transaction, where dynamics could also point to a referral mechanism, although it was not granted. But I think when you find time and refer to our website, you'll be able to read more about it. Lastly, I'll just mention that among the cooperation frameworks that is provided for under the law is for the Commission to also cooperate with regional or continental competition authorities. I mentioned here the East Africa Competition Authority. What if a transaction is to be notified to IACA and to the COMESA Competition and Consumer Commission? What would be the working arrangements in that particular aspect? So I think, Elizabeth, let me stop there. But just to note that we should be able to share these slides so that participants can read at their own free time. And we'll be very happy to take any questions. Let me stop there for now.
Thank you very much for that. I wish you had more time to do a deep dive into that particular topic, but we will come back to you. So, of course, in terms of regulation, we'll still have to extend beyond competition law and go on and have a discussion on ESG and ESG considerations, which will be guided by Ms. Felista. We'll change over to Ms. Felista and have a brief presentation of 15 minutes. Karibu, can proceed.
Yes, thank you, Elizabeth. I hope you can see my presentation and that you can hear me as well.
Yes.
Is the presentation, can you see the presentation?
Yes, we can see it.
Okay, great. So I will be looking at ESG and really the impact of ESG on mergers and acquisitions during the deal life cycle. And of course, as a new emerging trend, I think it's timely that this is under discussion. So maybe just briefly to take you through the presentation outline. We'll be looking at what is ESG, how it has evolved, the risk categories which were actually mentioned by the previous presenter. Just maybe slightly going into detail on what those risk categories are, and also the considerations shaping business valuation, how ESG risks are affecting business valuations, then ESG due diligence, and what are the focus areas that lawyers should be looking at from the start, And maybe we'll also have time to look at the common pitfalls as well as frameworks for allocating risks. So let me just dive in. I think it will be remiss of me not to go into what ESG is. And by definition, ESG is a framework for measuring the various efforts a company undertakes to be socially and environmentally responsible and how it complies with regulations and other forms of governance. Maybe for the environmental component, here really we're looking at how a company impacts the planet through its carbon footprint, how it uses its natural resources, if it has environmental permits or not, or if it should have and doesn't have, any pollution liabilities that it may have, its water usage management, and also importantly, how the business is ready to face any risks that may emerge from the changing climate. For the social component of ESG, here really you're looking at how a company treats its employees. It goes even down to look at how the company invests in the communities around it, its human rights compliance, the diversity, inclusion considerations. This year would be looking at the board. For example, is the board diverse? What are the inclusive practices that the company uses? And also supply chain standards as well as consumer protection practices. On the governance part here, with the component here, we're looking at the board composition as well as its independence. Is the board actually independent, and is it working in the interests of the company? We're also looking at its corporate governance framework, as well as for AML considerations, whistleblowing mechanisms. Really, this is just to give you a brief introduction into what ESG is. But now, specifically, how ESG and mergers and acquisitions, why is it important? And I think here it's important to note that ESG is no longer really looked at as something that belongs to the CSR unit or the marketing team. ESG is becoming increasingly important because it poses material, legal, commercial, financial, and regulatory risks. And actually, it has to be looked at every stage of a transaction, especially for a mergers and acquisition transaction, which we are now discussing. It's no longer really, it's moved far from being something that comes in as an afterthought at the end of signing a deal to something that has to be looked at from the beginning. It is no longer really owned by communications team and PR team. It's now coming to the board. It's ESG is actually, in fact, for Rwanda, I'll speak to Rwanda, from the regulatory point of view, the banking sector, the central bank is requiring that the board takes an active role in ESG. And so this shows you how material or how critical ESG is in board discussions. It's also, it's not just treated as goodwill. It's no longer something that good to have, but I believe ESG is now something that is a must-have. So as I said, it's now a source of liability. In fact, we'll even look into discussions of how authorities are now sanctioning companies for failure to comply with ESG requirements, and especially for those that are listed. So it's become very important. So what are those ESG risks that a company should be wary of or should be aware of? On environmental component, as I said, a company would be looking at what are the climate and transition exposures of a particular company you're interested in merging with or acquiring. Are there any emissions or permitting compliance issues? If it's an industry, is there land degradation issues, water and biodiversity issues? Is there a history of contamination as far as this company is concerned, or waste liabilities? What are those risks that the company has or carries? For social, we'll also be looking at, of course, labor practices, if there are any cases, employee cases, if there's any issues with the communities, how they are failing to relate to the communities, and also grievance issues and history of grievance issues with that community, with a particular community where the company operates. You're also looking at, of course, human rights compliance under the social aspect. Then the other one, I think, for governance, I would say here, and what has become very critical now, is beneficial ownership transparency. Is the company being transparent as far as the ultimate beneficiary ownership is concerned? And of course, this is also now highly regulated across East Africa, I believe. So it's really important here to note that lawyers are no longer expected to merely confirm legal ownership of assets or whether a company is complying with its statutory requirements, but rather required to identify what those risks are of ESG, quantify their impact on transaction value, negotiate contracts, and put in place provisions within the contract that will protect the buyer, and also advise the client on any disclosure and reporting obligations that need to be in place for the deal to be successful. So it's important to note that those metrics, they are called non-financial metrics of ESG, which they measure risks, but also evaluate the long-term performance of a company. And we'll see how it's not enough to say that this company is profitable. Is it sustainable? Is it going to be a sustainable company down the road? And all these elements under environmental, social, and governance those risks are the ones that actually inform the decisions during the due diligence. These are things that have to be identified from the beginning during the due diligence phase, not after the fact, not after the deal has been closed. Next. So now that we've identified the risks, the ESG risks, how do they affect the business valuation? And here it's important to note that when a company is complying with the ESG requirements, you'll see that it is reducing, there's obviously a reduced regulatory risk, then there's improved efficiency. You'll see that the business has lowered its financial costs. It's got good brand reputation because it's complying with the ESG requirements. You also see that investors are more confident in such a company because now investors are no longer interested in just the profit margins. They want to invest in a company that cares about communities, a company that actually adheres to human rights considerations, and also a company that will be resilient in the face of climate change, in the face of all the ongoing challenges that businesses face currently. And while on the other hand, on the flip side, the negative factors of ESG, you'll see that with a company that is not compliant, will have, of course, you'll have to contend with environmental remediation costs, and these have to be factored in the valuation of the business. How much will it cost to remediate some of those environmental breaches that have happened? Or how about the litigations that are in place? How about the pending regulatory investigations that may be ongoing due to failure to comply with ESG requirements? If there's any supply chain disruptions or labor cases, those are all the things that affect the value of a business during a merger and acquisition discussion. So I would say, for example, I'd give an example of a mining company. It may be the mining company is financially attractive on paper, but until the due diligence that a lawyer carries out reveals that there is a lot of unresolved land compensation issues and disputes, contaminated waste sites or non-compliance with environmental licenses, which will obviously may lead the investors to reduce the purchase price. That's one. They could even go as far as even terminating the discussions or requesting for indemnities to be put in place before the deal can go ahead. So I think this really goes to show the critical role that ESG plays in business negotiations and transactions. I will maybe speak to I mean, it's becoming very clear, for example, that DFIs and financial institutions actually requiring borrowers to comply with environmental and social safeguard standards. This is it's becoming common for DFIs to actually request that ESG strategies are in place, ESG environmental social plans are in place that have been approved and are being overseen by the board. So it's not it's no longer really a nice to have, but a must have, as I said, if you're to thrive as a business in this day and age. We've seen actually a lot of across the globe. We've seen regulatory enforcement and sanctions. There's been changes in the regulations within East Africa, but also outside East Africa, and fines. We've seen huge fines, for example, because of greenwashing. For example, in Frankfurt, there was a historically high fine of 25 million euros that were a bank was fined for greenwashing because it was acting like they're doing and complying with a lot of ESG requirements, because they know that investors are interested in this, they're interested in ESG, they're interested in a company that has sustainable business practices. And so they were greenwashing, and of course, due to that, they were fined a huge amount of money. So this is also, we're seeing a lot of impact on how ESG is becoming central in financing. You also have, of course, ESG covenants and reporting obligations. You'll see many of the agreements from lenders requiring ongoing obligations from the borrower to report on emissions, to report on its safety practices, to report on its labor practices, all depending on the industry, depending on the jurisdiction, of course, depending on the nature of the business. But ESG covenants are slowly but surely becoming part of, we're having a lot of covenants and reporting obligations being seen in facility agreements across the board. And also, of course, failure to declare or to disclose some of the ESG breaches and liabilities can also trigger acceleration or mandatory prepayment from lenders. So as a lawyer, what are the due diligence areas that we should be concerning ourselves with as lawyers? When conducting due diligence, I think it's important to note that this should be done together with the financial due diligence, the business due diligence that may be happening, or the compliance due diligence that is happening in the company at the beginning. This is important that ESG due diligence is also carried and conducted out from the start. And here, of course, depending on the business, you'll be looking at the permits. Are they in place? What are the waste management records, the history of enforcement actions that may have been taken on the company, where there's land, for example, if the company has warehouses or is a company that has uses land, or is a tower company that uses land with requires land titles. Are they in place? Are there any disputes for customary rights disputes that are in place? You'll be looking at labor and employment issues. Are there incidents that have happened, health and safety incidents with the company? You'll be looking at the anti-bribery controls, UBO ownership, as I said, and of course the reporting and accuracy of those ESG reporting, or the integrity of the reports that are being churned out. Are they actually accurate? So maybe briefly, just to look at the common pitfalls that maybe lawyers make during due diligence process. Of course, when conducting a due diligence on ESG, you may find yourself over-relying on the company that is selling, the reports that are the company, the seller's self-reporting information, which I think it's important that you treat the seller's ESG disclosures you have to test them. You don't treat them as fact, but rather as a starting point for independent testing. It's very important that basically the reports are not, it's a means to an end. It's not the end in itself. The fact that the reports are there is not an end in itself, but they have to be verified. It's not a checkbox style diligence. No, you have to running a generic template without actually knowing that it has to be speaking to the sector. It has to be jurisdiction specific or site specific risk. So it depends on there's no one size fits all checklist. I think this is important to note. So even when doing this due diligence, you have to be cognizant of the fact that jurisdictions are different. And of course, also ignoring informal land rights. This one, if you overlook the customary tenure and undocumented community claims, this could be a serious pitfall and actually cost a company quite a lot when this comes out later, that there are claims, informal claims and informal land rights, which were not taken into consideration at the beginning. You also have to understand the integration costs. How do we budget for integration costs? And also, of course, lastly, lack of monitoring covenants. Yes, you have put in place, you have understood the ESG risks. You're putting into place the mechanisms to manage those risks. But now, after closing, can we ensure that there is ongoing monitoring, covenants, and reporting rights for the buyer? This will obviously be embedded within the agreement. So what are the frameworks for allocating these risks? Now that we've identified what those risks are, in a merger and acquisition scenario, how would we handle these risks? And I think typically this would require ESG representations. You need the company that is being bought or is being acquired to make representations that it's compliant with applicable laws, environmental laws, labor laws, or depending on the industry, central bank regulations. You have to have those representations within the agreement. Also, of course, disclosures and sustainability reports, declarations, rather representations that those are accurate and they're complete, and that they give a true picture. And there's no greenwashing, so to speak. Similarly, we'll have, of course, disclosure schedules to consider. Once you have those risks, how can we manage them? I think the other thing I'd say is the big point here I see is on the materiality report, based, of course, on the risks that have been identified, which are based on the risk appetite. This would help the investor to identify and prioritize those issues. The issues are many, but of course now you have to have a materiality test. What are those risks that are very material, and prioritize them accordingly? And what are those that would actually have a significant impact on a business operations and its shareholders? For a bank, for example, that would mean if sanctions from the central bank. Those are looking at the history of sanctions from the regulator. That's critical for a bank. Or licensing, or cybersecurity risks, or its failure, supply chain interruptions. Those are things that would be critical maybe for the banking sector. The other risk allocation, I think, which would be now for consideration within a merger scenario, would be to ring fence the known ESG liabilities that have been identified in due diligence. For example, contamination or resettlement costs. Once those are known, you seek specific indemnifications from the seller. Also, I think another good practice would be to apportion payment that has to be retained pending the closure of or resolution of some of those claims. And for example, requiring that these amounts or those, rather the payment, the full payment can only be done upon completion or upon closing some of those issues that have been identified during the due diligence. Another one would be warranty and indemnity insurance. Here, of course, insurance that can cover those known ESG exposures, if it's environmental, if it's, for example, there's even actually requiring specifically environmental insurance as a standalone policy. Require that, depending on the industry, require that the seller in the deal has those insurance policies in place prior to the closure of the deal. Yeah. Another is a continuation to risk allocation, of course, is within this is also captured within the conditions precedent or the conditions subsequent. For example, as I said, requiring some of those prior approvals to be obtained from the regulatory authorities, from competition, from sectoral approval, from sector approvals. Those have to be, of course, obtained prior to closing. You could also allocate this risk really by requiring that an ESG action plan be put in place prior to the close of the deal as a condition precedent. Then there's also changes to the board if the board maybe is deemed not to be independent, or if there's issues of diversity, issues of inclusion. You require board changes, policy adoption, or compliance fulfillment prior to closing. So just to speak into a sort of checklist, I think that as lawyers would need to have in place for when approaching a merger and acquisition due diligence. Here, I would say ESG really, it's important to note that ESG should not be looked at as a separate work stream. I think it's important that we look at ESG as forming part and parcel of the other work streams, because normally during a merger and acquisition deal, there's the HR work stream, there's the legal work stream, there's the finance work stream, but now ESG should be integrated into those work streams because of the cost, the nature within which it cuts across. So, but of course, as I said, this is from the beginning, from when the letter of intent is issued or is being drafted. When forming those work streams, it's important to remember now the ESG due diligence work stream. And here, of course, the risks will differ significantly depending on the sector. But I think the idea really remains that it has to be dealt with from the beginning. Because of the nature of ESG, as we've identified, it's quite broad. You'll need to, of course, as a lawyer, work with the specialists, the ESG specialists, advisors from the early on, and these will work together with the legal as well as finance. Would also need to tailor representations, warranties, indemnities to the specific risk profile that has been uncovered during that phase of due diligence. Next, we need to build quantifiable ESG milestones for conditions precedent and also for post-closing covenants, just to make sure that those risks that have been identified are now mitigated. How do we mitigate those risks? As I said, through conditions precedents, through requiring indemnities, through post-closing covenants, making sure that those covenants are in place if it's having a ESG strategy, or if it's having an ESG action plan, making sure that the post-closing covenants are clear and that the monitoring is well catered for within the agreement. Then we need to ensure that the documents, the financing documents or the agreements themselves accurately reflect the ESG reporting requirements. I think this sometimes falls through the cracks. If it's a report that needs to be submitted regularly. For example, this I'm speaking from a financial point of view. If a borrower needs to be reporting on ESG every 6 months, just to make sure that this is well captured within the finance agreement or within the loan agreement. Then having an ESG register. We've guessed well and good, we've identified the risks. It's important that the register is also active and is put in place all through integration, so that it's not archived. I think one thing that is unique about USG is it's a continued. It's not, as I said, it's not an end in itself, but actually a means to an end. So this, as opposed to archiving those risks at closing, it's important that the risk register mechanisms are put in place so that this register is monitored on a regular basis, and there's efforts in place to ensure compliance and closure of those risks. So as I come really to the end of this discussion, I know the time is brief. We've been given only 12 to 15 minutes, and hopefully this will leave us time for discussions. I just want to really highlight what are the key takeouts that we as lawyers need to keep in mind. ESG has to be addressed from the full deal life cycle. It's very important, from valuation to diligence, due diligence that's being conducted, to the financing, to the contracting, to the integration of this merger and acquisition deal. So we also prioritize materiality. Here, as I said, yes, the risks are many, but what are those risks that could mostly affect the value of the business? I think those are, it has to be really done on a priority basis. Those risks that will affect the value of the business, the financial stand of the business, the regulatory approvals, and also completion of, rather the post-completion operations and the sustainability of the business. So those, it's important to have a sort of understanding of the materiality of the risks and to keep them in mind throughout the life cycle. Also translating ESG findings, which have been uncovered from the due diligence phase, translating them now into the representations, as I said, the warranties, the specific indemnities, those escrow arrangements that have to be put in place, the CPs, and the post-closing components that through, for example, ESG action plans and so on. So really, as I said, ESG is it's no longer a nice to have, it is becoming a must have. And we're seeing this through the regulatory changes that are happening, but also through the boardroom discussions. And here, one corporate governance expert put it very well. He said, integrating ESG considerations into boardroom discussions is really no longer optional. It's about future-proofing the business. So as legal advisors, as transaction advisors, it's important that we highlight and take into consideration, we equip ourselves with skills on ESG, but also now put the ESG considerations at the forefront when looking at legal risk and when advising a particular business during the process of a merger. So I think this really will bring me to the end of my discussion. And thank you, Elizabeth. I think I will have time for questions, if any, during the Q&A session.
Right, thank you very much. Yes, thank you very much, Felista, for that very good breakdown on ESG due diligence. And yes, indeed, ESG integration is no longer optional. So we'd like to just go straight into the next discussion, which will be handled by Bertha. And we'll now look at the future of M&A in East Africa. And then very quickly thereafter, we'll have a Q&A session. And yes, I just encourage the participants to continue asking the questions, the Q&A tab on the Zoom platform, or even in the chat box, and we will be able to handle them right after. Right, thank you. Karibu.
Thank you very much, Elizabeth, and all the presenters. They've done wonderful work. Good afternoon, everyone, and thank you very much to the East African Law Society for convening this webinar. As introduced, I'm Bertha Nanyaro, partner at Victory Attorneys and Consultants. At the firm, I lead merger and acquisition, investment, as well as infrastructure practice. And over the next couple of minutes, I will be taking you through the future of M&A in East Africa, specifically on trends, opportunities, and strategic consideration. As you will notice, is that the merger and acquisition is changing, and it's not changing at an abstract way, but in the ways that actually show up in the term sheets, in the closing conditions, and in the question that client keeps on asking, as well as agreement itself before signing. So, as you'll see here, the East African deal room, merger acquisition rooms, is changing, or it's being rewritten, and there are various issues or driving forces that are currently changing the narratives. And this includes geopolitical issues, regional competition clearance, ESG scrutinization, as pointed out by Felista, digital transformation, and the widening base of investors. In the old boardrooms, you will see that the decision-making were based on the price, asset, and the balance sheet. Due diligence was centered on the financial statements, as well as you'll see that the focus was more on the national authority, or national clearance authority. The new room is changing in the sense that the clearance is now shaping the timing, the pricing, and the conditionality. Why? Because you now have the national authority clearance, and then you have the regional authority. So the deal room is changing. Also, the diligence has expounded by more former presenters, is changing, is extending into ESG, data governance, cybersecurity consideration, multiple authorities, and therefore the legal advisors are no longer just the people who review the term sheet, but the strategic partner who shapes or design the deals themselves. As you see here, there are forces that are shaping the East African merger and acquisition, and you'll see regional integration, geopolitical realignment, competition law, AI, digital transformation, energy transition, infrastructure development, ESG, and new investors. But these factors, these 8 forces do not operate in isolation. They are here because they matter in every single transaction. Under the regional integration, under the East African community and the African continental free trade framework, as it is expanding the addressable market for the acquisition, you'll see that over the past 10 years, the person who was acquiring the business in Kenya would be more focusing on expanding the market just in the Kenyan market. But now we are changing the narrative. The narrative is changing in the sense that we are expanding, or we are acquiring the business that is operating across the region or is bound to operate across the region. So it's very important to look at the political environment of the region. It's important to look at the competition clearance of the region, and so forth. And here I have a very good example of the various financial sectors or financial institution that has expanded or has demonstrated the ability to see through the regional opportunity. And here I'll make example of the Equity Bank, Equity Group, and KCB Bank. We've seen these 2 banks expand over the country over the past years to all, or at least 5 to 6 countries across East Africa. And you see now there is a proclamation from our very own national bank, which is National Microfinance Bank, NMB, which has declared the intention to expand towards East African region, including and the first question be DRC. And then we'll see the geopolitical consideration or geopolitical realignment is also changing who is providing the capital and where the capital goes. For example, you see that China has been a pioneer in the infrastructure. So you see that the arrangement or the political alignment between the region or the individual state partner with the China is influencing where the capital goes and which kind of development or project they will finance. Also, you see the competition law, which has been expounded by the former presenter, the existence of COMESA, and now we see the COMESA Competition and Consumer Commission, as well as the operationalization of East African Competition Commission Authority in this year, and as we see, it received its first major or notification in January, which has been considered one of the very major transaction in the East Africa between the Safaricom and the Vodafone of Kenya. And also you'll see the energy transition, and this combines both renewable energy as well as arrangements that are going on in terms of we see the arrangement of EACOP, as I'll expound in the following slides. And also you see the AI, how it is emerging. It's one of the forces that are driving the major acquisition. It shapes how you do the due diligence, but also it shapes how the businesses or the investors are looking into investing in specific company or acquiring specific company, because they now prefer to look at the business which has the automated system, data storage. They look at how are you simplifying your operation and all that. And then you'll see here the regional integration, and I will a little bit of time here. As we all know, we started East Africa with the 3 countries, which is Uganda, Kenya, and Tanzania, but now we have 8 members, and the regime has now, they share as one competition regime, and that tells you how the regional integration is influencing the merger and acquisition across the region. And then we have the African Continental Free Trade Area, where we have, in Africa, we have about 54 members or partner states, but at least 49 up to this January had deposited the instrument ratifying the protocol. And then we have, the research shows that the Afrexim Bank projected that there will be a growth of 9.5% in intra-trade growth in 2060, which is like a growth of about 4% from the last year, which was 5.5%. And this increases, it shows that the investor are increasingly underwriting the East Africa as one regional platform rather than, or Africa as a one regional platform rather than isolated national. And this is why you'll see that we've moved, or the scenario has moved from being a country where you create a competitive platform. You just make sure that you are connected into the region, you have good infrastructure, you have electricity, you have all those factors or incentives that actually attract investors across the region, because they won't be selecting you if you are not collaborative or you are not integrated into one big market. And then you'll see here the high growth sectors that are likely to drive merger and acquisition. The 8 sectors are absorbing the major deals in terms of 2025, 2026, in terms of funding, transaction, regulatory activities across East Africa. You see the fintech and digital payments in Kenya grew for about $638 million in startup funding as of 2024, which represents 29% of Africa total. And then you have the banking and financial services. This is the dominant sector in the East African Competition Commission reporting as of 2026, as of July 2026. And you'll see that there is several players, and you see that there is a notification of Nedbank, which acquired significant amount in the NCBA. And then you'll see AIL, which is an investment holding company, and then you'll see Amechit. And also you'll see that there, in terms of this, you see that they are dominant in terms of the transaction. But when it comes to the volume, you'll see that the telecom did so well, or is still doing very well. And the result, or the message that you are getting here, is that the acquisition will continue to grow in terms of the sectors or platforms or the businesses that are integrating the payment system. They are bringing the open banking, the data portability reforms, and widening the the scope of operation. And you see that they recorded about 2.2 billion of transaction volume, and this was significantly on the deal between Vodafone and the Safaricom of Kenya, as well as Tarifa, which was mentioned earlier by Ian. And then you'll see that the renewable energy and power is also driving the force, or is the sector that is driving and will continue to drive. And this is so obvious because we have so many we have energy, something that is Africa Talk. We have Africa Mission 300 mission, whereby by 2030, African state members have declared that by 2030 they have to electrify 300 million citizens across Africa. That is opportunity, and that presents the area where the mergers and acquisition and the investment volume will continue to flow in. Then we have the transport and logistics. This is something that I believe that everyone in this room today, or if you don't know, but they say you should know by now. Transport and logistics, we have, why are we creating one common market? Why do we need common market? Why investors are coming is because we are located strategically. One country could provide a strategic opportunity in terms of transport, logistics, and ports across other states. And the specific examples will be given for example, here in Tanzania, we have several roads, we have several railway, and there are also incoming infrastructure development in that specific area. We have ports that is currently doing so well. Of course, we have the Mombasa port, but Dar es Salaam port also. These are the two major players in terms of port in East Africa, and they continue to drive volume of transaction, and they will continue to do that. And we also have, in terms of Tanzania, we have Tazara. Tazara is Tanzania Zanzibar Railway, and there is a new project which is currently aimed at renovating or revitalizing the Tazara Railway in order to increase the connectivity between the country partner state, between Zambia and Tanzania, and all the way to now. If we have regional road that goes all the way to Kenya, that is an opportunity. Then we'll see the agribusiness and food supply. And the report shows that there is a huge increase in the sector, especially in our partner state, which is Uganda. We have Tanzania, of course, we have Rwanda. And one among the transactions that have been reported is Zahad Holding, which is one of the seed manufacturing company, which was reported also at the East African Competition Commission this year. And then we have the health sector, which continues to grow. And the research or the stat shows that Kenya is leading in this sector. Of course, Tanzania comes down to it, especially with the establishment of Mloganzila Hospital, which is currently also able to receive patients across the region. And then we have mining and the critical minerals. This is the global issue, and as well as because there is a global demand in terms of critical minerals and what they could do in terms of EV, in terms of energy and all that. It has recorded in Tanzania alone $10.9 billion in investment commitment 2015 and 2025. Then we'll go to now infrastructure specifically. You'll see that from our experience, infrastructure project does not just stand alone, like you say, for example, ECOP, you say it's one project. No, itself creates downstream opportunities in terms of who are the financier, who are coming in as the financier, who are the subcontractors, who are the people who are doing the joint venture into implementing the project, who are the service providers. And examples of the project that are creating value in the merger and acquisition and becoming a merger and acquisition catalyst is Tanzania Zambia Power Interconnector project. This was a project which originated, was designed since 2017. And it came all the way from, it was an energy transmission line that was coming all the way from Ethiopia, Kenya, Tanzania, Zambia. So this is the phase of Tanzania and Zambia, but the Kenya and Tanzania is part of it is done. So you'll see that it's linking the regional and East African power pool. And then we have the TAZARA, as I said earlier, and then we have TAZARA, Zanzibar, Zambia, and Tanzania. And then we have Tanzania and Burundi. Those all are the regions. To speak of one country to the other, so it's a linkage. And then we have this mining, Zinjin mining concession, which is the company that has been engaged to do the development of Kigoma Port, again, logistics, port, transport, and all that. And then we have major of all, which is East African Crude Pipeline, EACOP, which is linking Uganda and Tanzania. Not to forget about the new deals that are coming in the of course infrastructure, but at the same time energy. Dangote Refinery, which is about it is said to be $17 billion of investment. And the good thing that I liked how Ian put it, that the investors are coming from the very same energy. The confidence is there. The investors are changing in the sense that we are used to having the Europeans, we are used to having the American, but coming in. One of the good example, because Dangote is a Nigerian, and then you see that the government of Kenya is investing about $166 million as part of its commitment. And then Mohammed Enterprise of Tanzania has also pledged about $100 million as part of the construction investment. So again, regional collaboration, regional investment, investors changing, but remaining at home. Then we have another factor that is driving, or at least forcing the deals in the East Africa, which is competition authorities. I won't spend so much of my time here because it has also been expounded by Mr. But for the purpose of East Africa, we see that the East African Competition Authority became live here, and it received its very first case, or very first notification between Vodafone Kenya and Safaricom acquisition, which was verified to both East African Competition Commission Authority and Commercial Competition Authority in January 2026. And this all tells you how big the market is, how the region also changing. We are no longer focusing on the national. We recognize the investors need to have one pool, one-stop center, and this is why we operationalize the East African Competition Commission, even though the COMESA had existed over the years. Then we have the digital transformation, which
sorry,
is
Ms. Nanyaro, maybe
Yes.
we can conclude in 1 minute because of time. Thank you. You can proceed.
All right. So we have digital transformation, which is also driving M&A and AI. It's shaping how we are structuring the deal, how we are doing the due diligence. Then we have what are the strategic consideration when you are doing the deals. You have to do the deal structuring strategically. You have to check the regulatory approvals, conditional precedent, due diligence, intellectual property, and all cross-border tax implication, ESG, cybersecurity issues, political risk, and all that. Then where the lawyers can do the real value, you have to be the strategic deal breaker, a deal closer. You have to be aware of ESG. You have to be aware of the East African, the regulatory framework around the region. And then in the next decade of M&A in East Africa, we'll see that by 2027, we expected that after African Continent Free Trade Area Investment Protocol advances towards entry, and then you'll see that by 2029, by 2028, we expected to have, there is an initiative which is going on, and the expectation is to have one continental competition authority, which is targeted to be established by 2028. And then on the ESG regulation, you'll expect that by 2029, you should have a fully application of the EU corporate sustainability due diligence directives. They are ongoing as of this July, but they'll go broader now. They'll go broader as of 2029. We'll be having this become very, very mandatory. And then by 2030, 2030, you'll have the World Bank, which I spoke about, the electrifying 300 million individuals across Africa. And then what will define generation of M&A lawyers in the next couple of decades? You have to have commercial awareness, financial literacy, specialization, geopolitical awareness, and as well as its implication to the deal, negotiation skills. You have to have communication skills, regulatory awareness, cross-border experience. So you'll no longer be pledging yourself or selling yourself as a lawyer based in Tanzania. You'll be selling yourself as a lawyer based in the region. So these are the very important things that we should keep in mind while we navigate this merger and acquisition. And because Elizabeth, you've given me very few minutes. I'll just give a takeaway. Now, the East African remain. Ian had said this. The market is very confident. Investors are very confident, but the very crucial issue remains the regulatory disharmonization. So we need to harmonize. We need to see how we can shape the regulations that accommodate the regional integration. Competition regulations led by East African Competition Authority is now central to the transactional planning, and then ESG become the evaluation and financing. Felista has said that technology is transforming both the deal targets and deal execution, from AI-assisted diligence to digital asset valuation, as had mentioned by Mr. Ali of COMESA. Then lawyers who combine the legal experience with the commercial understanding of the business of the deal, regulatory awareness, the technological insight will lead the next generational merger and acquisition or deals. Thank you very much.
Thank you very much, Ms. Nanyaro. Of course, we'd love to have a much longer session to deal with probably each of these aspects. But again, the SETI may have to arrange another session for us. But thank you very much. And because of time, we'll ask the SETI or our host to allocate us 10 more minutes so that you can go straight into the Q&A session. Unfortunately, we cannot handle all the questions that have been asked, but you can see that a few have been answered directly. I'll just sample a few, and then we can be able to close the session in 10 minutes. So I'll pose a few questions to our panelists, and then we can close immediately after. And ask our panelists to strictly, if possible, adhere to at least 2 minutes, or rather at most 2 minutes, so that we can be able to keep time. Thank you very much. And also we want to thank our audience for being with us until now. And if there's any burning question, you can also still include it in the Q&A section. So I'd like to start with Mr. Mutibwa. The first question to you is, how are geopolitical developments influencing investment decisions and transaction structures across the region?
Thank you, Elizabeth, and thank you to my co-panelists who have broken down these things in greater detail. Of course, geopolitical occurrences or events really affect investments, affect FDI, affect the way different persons invest their money. Specifically for FDIs through the different arms that we've seen that are investing into East Africa, we see that many of them are worried, especially when it's an election year, like for example in Uganda, an election year for this year. Many get worried and wonder how the elections or the post-election will impact the investment. So some of them really look at exit at that point in time, or they look out for a way they can delay an investment decision. Because of what is happening. Sometimes geopolitics, not even the politics happening around East Africa, but those happening out of East Africa can also affect investment and the cost of money as well. So sometimes you see a closure of Strait of Hormuz may be so far away from East Africa, but that has an implication on how people are investing. So the geopolitics has a big effect. Most times the financings come with this political risk insurance, which covers most of the political risks, and they are sometimes given that leeway to allow for the political risks. In Uganda, it's more stable than comfortable. In Kenya, it's more comfortable than certain. So we see that the way these political whims are playing in different jurisdictions impact investment. If you look at the social heat map, most investments go to Kenya because it's more politically stable, so to speak. Uganda follows suit. You have Ethiopia, which is coming in strong. A country like South Sudan or DRC have little impact on investment because of the way the structure of their geopolitics. But I know for a fact that most of the political players or most of the investors are shy to invest in an election year and or look at exiting towards election year. So they really have an impact on investment.
Right, thank you very much for that. We'll have the next question that is going to Ms. Kilmanuka. Apologies if I have mispronounced your name. How do you think the proposed common currency for EAC will affect M&A in EAC? Yes, I don't know if I'm audible. Actually, the question is for Bertha. How do you think the proposed common currency for EAC will affect M&A in EAC?
Elizabeth, can you repeat the question, please?
Right. How do you think the proposed common currency for the East African community will affect mergers and acquisitions in the East African community?
I do hope that the proposed common currency for the East African community will effectively influence mergers and acquisition, because at the end of the day, you're looking into the value that the integration is bringing into the businesses that are being brought into the region. So the proposition of the currency also bring into the harmonization and the transaction value in terms of East Africa currency differs. The Tanzanian currency, and then we have the Kenya currency, and then we have the Uganda currency. These currencies are not stable. So I believe that the inclusion or the introduction of the new currency will influence the measures and acquisition in terms of creating the value of the business in the region, but also stabilizing the region itself. And also you see, like, there is one example we do transaction in our own currencies, but at the end of the day, we use our currencies across the region or the country that we live in. But when it comes to transacting across the region, say I'm sending money to Kenya, or I'm doing the purchase in Kenya, or I'm doing the Kenyan is doing the purchase in Tanzania, the currency become the big issue. Why? Because the Kenyan currency, when it goes to Kenya, the Kenyan currency, when it comes to Tanzania, it loses the value, or its value is a little bit higher compared to ours. But then we are forced to stabilize or to use the stable currency, which is USD. And this applies to most of the trade that we are doing, not just across Africa, but even globally. We do trade with Asian, we do trade with Arabs, we do trade with just about everyone. So we are forced to use the USD. So this use of USD is destabilizing our own currency. So if we have to stabilize the economy, we have to start with the stabilizing our own currency. Now stabilizing our own currency with the regional integration, we cannot stabilize that using like multiple currencies while we call ourselves one common market. So we have to establish our own currency, and I believe that will add value so much to the economies of the region as compared to when you are using multiple currencies, and at the end of the day you are not able to trade internationally or regionally. We are also forced to use the currency that is not actually ours. So that will be my very brief response to that one.
Right, thank you. Thank you very much for that answer. And we'll have a question that is posed to Ms. Felista. In what ways are ESG considerations influencing valuation, transaction structuring, and post-acquisition integration?
Yes, thank you, Elizabeth. I had an issue unmuting myself. I hope you can hear me now. So for ESG considerations, as I mentioned in my presentation, they do influence the valuation definitely of a business, because if there are any negative ESG risks that have been identified, these would obviously, as I said, for example, if there are land disputes or labor disputes, these would affect the valuation of the business, and even maybe what the investors are willing to pay at the end of the towards the close. It would affect the value of the business definitely, but also the structuring, because here, of course, you'd have to put into place the mechanisms to mitigate those risks that have been identified throughout the due diligence of a particular company. That would mean, of course, the conditions precedent to closure, the indemnities or representations and warranties that may be required from the company, and also, of course, any conditions subsequent that have to be fulfilled prior to the close or to close being attained. I think it's important that these the risks are first of all quantified, because of course different risks will have different impact on a business. As we said before, depending on the industry, depending on the sector, if it's an issue of, for example, within the banking sector, if it's an issue of sanctions, I think this would be given maybe more weight. So I think it's important that there is a sort of prioritization of those identified risks, so that those that are likely to impact a company's value are given more, or even a company's value or a company's approval process are prioritized accordingly. So I hope that answers your question, Elizabeth. Thank you.
Yes, it does. Thank you. Thank you very much for that. Now, our last question is to Mr. Kamanga. And the question is basically, how can lawyers effectively manage cross-border regulatory risks across multiple jurisdictions simultaneously, while still preserving the commercial certainty? So how can lawyers effectively manage cross-border regulatory risks across multiple jurisdictions while preserving commercial certainty? Thank you.
Thank you, Elizabeth. And I also take the opportunity to thank my fellow panelists for the wonderful presentations. I've learned a lot as well. To the question, I think I'll just comment on one aspect. I think what is very much clear, and what lawyers should be aware of, is that as regulators, we've got processes in place. We've got transparently so procedures that lawyers have to follow if you have to get your approval from a competition authority. And one aspect that perhaps needs and requires management from the lawyers and the business side is the timing aspect. From a COMESA, Competition and Consumer Commission perspective, we do have a number of processes that can aid in that respect. One of which is pre-notification consultations. So the Commission does allow parties to approach the Commission where there is uncertainty on how or whether a transaction requires the Commission's approval. I think that is something that should be explored, and we encourage parties to approach us. I did also mention in our presentation the aspect of advisory opinions, the aspects of comfort letters, where a lawyer is sitting in Nairobi and is advising a client, and they are not sure whether this transaction should, be notified to the Commission, or maybe it's an ESG transaction, maybe it's just a national transaction. So the risk of not approaching the Commission is that if the Commission comes across the transaction after implementation, with the suspensory nature of our regulations, this may be a risk that you could have avoided. But I think the Commission has got those processes which I think lawyers can take advantage of, and it may mitigate, risks in the context of these transactions. And Elizabeth, if I could just say one more thing as well, I like the presentation by I think the one that spoke about ESG.
Miss Felista.
Felista, I think that was spot on some of the considerations that transactions should also put in place. And the Commercial Competition and Consumer Protection regulations have also made it very clear on public interest considerations that will be factored in the assessment of measures, in addition to our normal competition assessment. And one of the factors we have made very clear there, in addition to employment effects, is also environmental considerations. I think it's a very important point, and I like that presentation because it really has also opened our eyes on some of the considerations which are already there on the market, and our regulations have really, recognized that synergy. So let me stop there, and thank you so much for this opportunity.
Thank you very much, Mr. Kamanga. I'd like to bring today's session to a close. Thank you very much to all our participants, and a sincere appreciation to our distinguished panelists for their invaluable insights. Today's discussion has demonstrated that successful mergers and acquisition practice increasingly requires legal excellence, commercial awareness, regulatory understanding, and strategic foresight. So on behalf of the East Africa Law Society, I thank you once again to all our speakers and our participants, and it's been a privilege to moderate this session. I believe our speakers will be willing to share their slides with the participants or with the society so that they can share it with the participants, because we've learned a lot today. And we look forward to welcoming you to future programs. Thank you very much and have a good rest of the evening.
Thank you.
Good evening.
Thank you. Thank you, Elizabeth, and the rest.
Thank you, everybody.